So, bad news from the Fifth Circuit. First offense, possession of a controlled substance, which is just about every crime and every drug possession crime except for the small amounts of marijuana, is now an aggravated felony for immigration purposes as a drug trafficking offense. Now, the rule on marijuana is essentially if it is a second conviction for marijuana, it is a drug trafficking offense, and it is an aggravated felony because the federal definition of a felony offense for marijuana is a second possession offense. Now, there is some good news from the Fifth Circuit Court of Appeals. And the good news is, in April, the Fifth Circuit Court of Appeals held that Texas felony driving while intoxicated offense was not a crime of violence because there was no intent to commit violence. Because there was no intent to commit violence, it was not a crime of violence, and therefore it was not an aggravated felony for immigration purposes. So this is good for those people who are convicted of felony driving while intoxicated. The Board of Immigration Appeals has reopened several of my cases which I had on appeal. Those cases which the appeal had already been granted, they're granting motions to reopen for purposes of termination. Under the federal system, there's certain people who are subject to detention. You know, this is like the only time of the entire year where I talk this fast because I have so much stuff to get in, right, and so little time to do it. And that's my second crack about the 20 minutes that I'm allotted. But detention, what happens? Your client gets arrested. You know, immigration, they do not care anymore about the people who are illegal, who are at the flea market or the pulga, as we call it. They do not care about the illegal people who are walking in East Austin or in South Texas. What do they care about? Criminals. Okay, criminals are good politics. So in Austin, the Austin immigration and nationwide, they go to the jails. So your client gets arrested for whatever offense. You have an immigration investigator whose only job is to go to the jails and find criminal grounds of deportability against those aliens who are arrested. If he's been arrested of 2 or more crimes involving moral turpitude, regardless of when the crimes occurred, he's subject to mandatory detention. If it's an aggravated felony offense that took place after October of '98, he's subject to mandatory detention. I recently completed a case for a gentleman who was arrested for soliciting prostitutes in Waco, but that wasn't really the problem. The problem was that he had 2 Class C theft offenses that took place in 1989 and 1990 in Waco. And he was not an aggravated felon. He was subject to mandatory detention. He was a refugee from Romania. Because the rhythm of people who are subject to mandatory detention and the times that they go to jail, it's a lot like the federal system. You go to court every 3 months. You go to court every 4 months, 6 months. So it took so long to get this man to his final tribunal that in the interim, I made his wife a United States citizen. She petitioned for him again, filed a visa petition. It was approved, and he adjusted his status. But that process took 20 months, a year and 8 months. And during all of that time, for 2 Class C thefts, he was held in jail subject to mandatory detention. But he adjusted his status, even though the judge chastised him for his explanation about he had actually had another prostitution arrest in Waco, and both times he just said, well, I just saw a lady walking down the street. I thought she needed a ride. You know, funny thing about prostitution, it is not a crime involving moral turpitude. It is a separate ground of excludability. But it is not a crime involving moral turpitude. And the only thing I can think of is, you know, who writes these laws? It's got to be Congress, you know. And so Congress would have made it a CIMT if they'd wanted it to be a CIMT. But no, it's its own separate little problem area for people who have a few little problems. Good news from the Board of Immigration Appeals is they've reaffirmed a couple of long-standing positions, and they've kind of like said, decided another case in New York. Juvenile adjudications are not convictions. And now, if a juvenile is certified as an adult, then it is a conviction because the process changes after that. Now, the matter of Roldan that I referenced to earlier, and which is in the material, said that the outcome of Texas criminal case is really where a person is discharged from probation and the plea of guilty is set aside and the indictment or information is dismissed. Prior to matter of Roldan, I would tell every lawyer that called, well, your work is not done. Even though it's 5 years later, you go back into court and you get the judge to do that for you, because up until matter of Roldan, that was enough to take that off the record. Matter of Roldan said no. So what the Board of Immigration Appeals did in a New York case was they said this gentleman had had a case that was discharged from probation, and they specifically found that the discharge from probation was not part of a rehabilitative statute. So I'm not exactly sure, because that is a very recent case about 3 weeks ago, whether the impact or what the impact of that will be in Texas. Though I've always said since matter of Roldan, if you could get a district judge or a county judge to specifically say in an order, and this is my pitch to all the judges out there, specifically say in an order that the discharge was not part of an act of rehabilitation, that would handcuff the Immigration Service. On to page 2. I haven't looked yet. Am I at 20 minutes? I only get 20 minutes. Have I complained about that yet? I've got 3 more minutes. Oh, my goodness. Okay, guns. Doesn't make any sense. You can be deported for guns, but they can't keep you from getting your papers unless you're trafficking. If you're trafficking in guns, forget it. It's an aggravated felony. It's been in the book since 1990. But if you possess a gun, you can come and go. It's not a ground of excludability. But if they find out that you have a gun, like say you go and apply for citizenship and you give them your fingerprints and they go and they find all of this, they can put you into removal proceedings. Now, the Immigration Service does have prosecutorial discretion. They don't deport everybody, okay, but it's up to the immigration lawyer to get in there and say, this is why you should not prosecute or put this individual into immigration proceedings. Okay. Now, crimes of violence, assault, simple assault is not a crime involving moral turpitude, but if it's against your spouse or a family member, and once again, you've got to read the definition that's in my paper, it could be a crime of domestic violence, which does not require that you be sentenced to a year. Okay. Can't keep you from getting your papers. You can apply for a waiver for that. Okay, but it could get you deported. Now, an assault on a spouse can be an aggravated felony if you're sentenced to a year in jail, probated for whatever period of time. But don't forget, so when you're working out those plea bargains and you're trying to cut a deal with the prosecutor or Mr. Prosecutor or Miss Prosecutor, when you're cutting the deal with the defense attorney, don't forget, you know, you can get a lot from the defendant. You can get a lot of rehabilitation from the defendant. You can serve a lot of the interests of justice by working out just the right deal and working through all of these papers. Now, it's always better, because of the way the law's worked out, if you don't have your green card yet. And most of you are probably familiar with the extension of Section 245. Well, actually, I don't know. Y'all aren't immigration lawyers. Congress in December extended Section 245I, which said basically anybody who filed their papers before April the 30th of this year, if they don't get caught, when they finally get to the front of whichever line, and some of those lines are 8 years, 5 years, 10 years, when they get to the front of the line, if they haven't been caught and they haven't been put into removal proceedings, can pay a $1,000 fine, good idea, INS wanted this, and get their papers in the United States. Congress is contemplating the very same thing. Our own president wants Section 245I extended for another year. Okay, and Congress and the House are kind of arguing back and forth about what they're going to do. And probably what they're going to do is they're going to wait to December and they're going to extend it for another 6 months, which will effectively give everybody the year that they wanted from April or May 1st of this year. So you're going to have a lot of people who are applying for green cards who are going to be your defendants. Now, they'll be put into removal proceedings. You know, they might very well be eligible to immigrate, do their immigration process in front of the immigration judge, which in a lot of ways is better, because with a judge, you more or less know what you're going to get. With INS in San Antonio, you have 40 examiners, but you only have 3 judges. And I know those judges. It's my business to know those judges and know what they like and know what they don't like. So you're going to have a lot of people who are waiting to get their papers. You know, Congress, the president of Mexico and the United States are talking about an amnesty. They're talking different ways of guest worker programs. You're still going to get lots and lots and lots of clients who want to stay here, who possibly have the right to stay here. I urge you to take these materials with you into the courtroom and use them. I'm going to update them, and as long as I'm being asked, as long as I keep getting asked, I'm going to come back and address you. I want you to take what I have said today in the materials and multiply it by 1,000 to all the different defendants that you will see over the next year until I come back. I'd like to thank you very much for being here, and I'd like to thank my God for putting me on this earth, and excuse myself. Thank you all very much.